All right, John, the bread and butter, what I do in the military, or what I did in the military and what I do as a civilian lawyer, courts martials. So, what can a client expect if they get that dreadful day that their commander tells them, you're going to be court martialed?
Well, first comes the formal UCMJ charges, as we know. And what the client can expect there is an official and formal reading from the commander who preferred those charges, whether it's in the commander's office or elsewhere. The commander reads the formal charges, hands the accused a script and a sheet of the charges, and it all starts from there.
And usually attached to those charges are some evidence of each specification that they then take and go see TDS.
Correct.
And the question is, do they want to hire the law office of William Helixon to represent them after that? I would tell them, if you can afford to hire us, you should hire us. I've tried over 100 cases to a jury verdict in the military. And you're not going to find somebody at TDS or an ADC or any detailed military counsel that comes close to that. So the experience that we have representing soldiers in a courtroom is just incomparable to what you get in the military. The second thing that happens after they're read those charges and they go see TDS is there is a hearing that's set. It's called a preliminary hearing. What happens at that preliminary hearing?
That's a preliminary hearing. It's called an Article 32 hearing. And there's a determination made as to whether or not there's probable cause to believe that these offenses occurred. And if so, should they go forward onward to a court-martial then?
And so this Article 32 investigating officer listens to all the evidence at this preliminary hearing and then issues a report and makes recommendations to the convening authority.
That's right.
Now, is the convening authority bound by the recommendations of the preliminary hearing officer?
Absolutely not. Much like the appointing authority on a 15-6 is not bound by the investigating officer's findings and recommendations, the same case here. The convening authority is not bound by the Article 32 investigating officer's recommendations.
So after the Article 32 and they get the report, then they package that information up, they being the government, and they send it back to the convening authority saying, we want you to refer these charges. What happens next?
The convening authority has a choice then, whether or not to refer those charges to a court-martial and what kind of court-martial to refer those charges to. Or the convening authority could do something alternative, either dismiss the charges altogether or send them to some other type of disciplinary process.
Now, there's been recent changes as to whether or not a commander can refer certain cases like sexual assault cases to court-martial, and that's changed. It's no longer the convening authority. Those cases go to a centralized Department of the Army organization they call OSTIC. And what they do is it's a centralized group of lawyers who are headed by a one-star general. They have 3 full-bird colonels that work under them who run each branch, and they're the ones that make the determination whether or not to refer the case to a court-martial.
That's a very interesting change.
And when that change sees light of the day, what happens is not only do these 3 judge advocates who are colonels make that decision about going forward and prosecuting the case, they've got a litany of lieutenant colonels that work under them that now are the prosecutors for those cases. And they are, guess what? They are the most seasoned, the most experienced, the most prolific litigators in the United States Army who are trying those cases. And they're trying those cases against Trial Defense Service that has 2 years of experience defending cases.
You know, Will, the deck, before these changes, the deck had already been stacked against the accused. I mean, when you're an accused and you're facing UCMJ charges in a court-martial, the weight of the world is upon you. Now with these changes, wow.
So whether or not you get your case referred to court-martial by the traditional method through a convening authority or through the new method through the centralized judge advocates in DC, it winds up going to a military judge. What's the first thing that happens once the case is referred?
First thing that happens once a case is referred, all the evidence that was used to refer those charges is then given to the defense. That's called part of our discovery process.
All right. And so the defense gets that, and we have to get that before what's known as an arraignment. What is an arraignment?
Arraignment is a court proceeding, fairly simple, usually only takes about 30 minutes, whereby the charges are formally announced in court to determine whether or not the charges are legitimate, properly written, properly administratively processed, and whether or not the court has jurisdiction over the accused.
And that's where the accused is given his rights by the military judge. The right to remain silent, right to counsel, who he wants as counsel, what's going to happen if he absences himself, those preliminary matters.
Right.
It's usually at this arraignment that a trial date is set, either right before or right afterwards. And that's usually done through negotiating with the government when you're available and when the court's available. And so they pick a trial date. And so once that trial date is set, is there any other court dates that happen from the arraignment to the trial date?
There could be what's called pre-trial motions that are asserted either by the government or the defense. And these pre-trial motions are matters of law that must be decided, argued by both sides, and then decided by the military judge as to whether or not particular types of evidence or particular matters of law will present itself then at the real trial.
Right. And this is where, if you've been denied a witness as the defense, you have a motion to compel a witness. If you've been denied an expert, you have a motion to compel expert. If you've been denied discovery, you have a motion to compel discovery. If you want to suppress confessions, this is where you suppress the confessions. And there's a large litany of potential motions that could be litigated in these early sessions that could dictate what happens at the trial.
Correct. They're very important because they can manage and dictate the entire course of the trial.
So trial date rolls around, the defense has been prepared, they've done their investigation, they've litigated their motions, and now you walk into court and it's the day of trial. What's the first thing that happens?
The first thing that happens, if it's going to be a panel case, is the panel, the jury members, are going to come in and announce themselves and be present in the courtroom for what's called the voir dire process.
Well, in Texas we call it voir dire, but I'll tell you that the process is this. It's where the defense and the government get to question those potential panel members. And first the questioning is done as a group. All the panel members are in there. And then after that's done, after the judge is questioning them, the government is questioning them, and the defense is questioning them, they're excused. And we then say which members we want to call back. I cannot remember a court-martial that I've litigated in the last 10 years where I did not request every single member to come back. All right. There was a reason why I wanted to follow-up questions for every single one of those members. So it's a long process. It ranges anywhere from 2 to 4 hours, this voir dire process that we go through. And through the questioning of those members, once all the questioning is done, both the group and the individual questioning, they're again dismissed, and we get together as a group in the defense and say which one of these members can we kick off the panel because of cause, meaning there's a legal justification, or which ones do we want to get rid of as a peremptory challenge, meaning we can just throw one of them off for lawful reasons, right? And those lawful reasons are anything other than discrimination based on race or gender or sexual orientation.
And why is this so important? Why do you take so much time to determine who is going to sit on your jury panel?
The reason that we do that is we want to determine who will be most favorable for the defense. Who's more apt to listen to what our defenses are? Who's more apt to be questionable or skeptical of the government's case? Who is more able to hold the government to that high burden of proof of beyond a reasonable doubt? We want the best panel members possible to hear our case. And after the voir dire is done, after it's completed, the judge excuses those who were dismissed, calls the panel back in, and seats them. And then the judge generally says, "Government, do you have an opening statement?" And the government provides their opening statement. The defense is then asked to give an opening statement, and they can do one of two things. They can either give their opening statement, or they can tell the military judge that they're going to defer their opening statement until the beginning of their case. And there are strategic reasons why you may defer your opening statement until you open your own case. Once the opening statements are done, the judge turns to the government and goes, "Government, call your first witness." And that's where the trial starts. The government calls their first witness and they put him on the stand. And what happens then is the government questions the witness. Once they're done, the defense gets to cross-examine that witness. The government then redirects that witness, and then the defense recrosses that witness if necessary. The military judge would then ask any questions that they have of that witness, and then the panel is asked if they have any questions of that witness. And the panel members will write out those questions and submit them to the bailiff, who give them to the judge. The judge reads them. The judge then hands them to the government and hands them to the defense. We write objections on them. The judge then looks at them again and then asks those questions to the witness. And once that process is done, the military judge turns to the government and goes, "Government, any additional questions based on those questions?" And then asks the defense, any additional questions based on that? And that goes through for each witness in the court-martial. And then at some point in time, the government stands up and goes, "The government rests." And at that point, the government is done presenting their case. When the government's done presenting their case, the defense can file a motion, and that motion is the motion to dismiss because they failed to prove their case. I have never won a case at this stage, right? So oftentimes I don't even submit that motion because it is such a hard motion to win, and it really takes away from me preparing and being in the moment of the trial. The military judge then turns to the defense and says, "Defense, do you have a case?" Because the defense doesn't have to put on a case. We could rest immediately after the government's case and go straight to the rest of the trial. But I say yes, and they say, "Call your first witness." I call that first witness, put him on the stand, and they testify. Then the government crosses, I redirect, government recrosses, and the same procedure goes through with the judge asking questions and the members asking questions of the defense witnesses. And that proceeds all the way to the end until the defense stands up and says the defense rests. And at that point in time, the military judge will look at the government and go, "Government, do you have a rebuttal case?" Most of the time, the government doesn't have a rebuttal case, but sometimes they do. And when the government has a rebuttal case, the process of those witnesses repeats itself. And when the government's done with the rebuttal case, the military judge will turn to the defense and say, "Defense, do you have sir rebuttal?" And we either do or we don't. And if we do, the process repeats itself until the case is over. And at that point in time, the military judge will call the members in. They've already been in, but they've usually been given a recess and they come back in, and he will instruct the military members on what the law is. And he'll give the basic instructions, right? Just preliminary instructions. And then they will be released. And these are just preliminary instructions like, we're going to take this break. We're going to, have instructions at another time. You need to go have latrine breaks. You need to have, whatever those administrative instructions are. The real instructions dealing with the case happen after argument. So once the government and the defense has gotten together in a session outside the presence of the members and have argued and talked about what instructions should be given to the members, the judge decides what instructions to give. And then he calls the members in, goes, "Government, do you have a closing argument?" The government gets up, closes, turns to the defense, "Defense, do you have a closing argument?" Defense gets up, makes his closing argument, and then the government is given the opportunity to give a rebuttal closing argument. And in that rebuttal closing argument, the defense 99% of the time doesn't get an opportunity to respond, because the government gets to open and close closing arguments because they have the burden of proof. The burden of proof, which is beyond a reasonable doubt at a court-martial. Now, once all the arguing is done, the military judge then instructs those members. and he gives them all those instructions that we had talked about earlier with the government and with the judge as to what instructions govern that particular case. And when those instructions are done, the military judge gives the members a worksheet. It's a merits worksheet where they go through each of the allegations to determine whether they're guilty or not guilty. And then they are dismissed to deliberate. And then the military members go back and deliberate. If in that deliberation process they have a question, the bailiff comes out, asks the military judge, hey, here's the question that the members have. We call the members back in. The question is read out loud by the military judge. The defense and the government then get to object to that question. Or say, here's what we propose the answer to be. We give it back to the military judge. The military judge then answers that question based on our input and the law. They're then sent back to continue deliberations. If there are any additional questions, that process repeats itself until you get that knock, and it's like the members have made a decision. And let me tell you, that is the period of time when the members start deliberating until the period of time when they're done is the most excruciating period of time in the world. And so the members come out, the judge will ask them, have you reached a verdict? They announce that they have. The judge then looks at the military member's worksheet, sees that it's in order, gives it back to the president of the board. Then, something that I'll never ever forget in my lifetime, accused and counsel, please rise. And we stand up. And the board president, not the board president, but the panel president then reads the findings to the accused. And there's nothing more gratifying than to hear the following. This court-martial finds the accused, whatever his name is, of all charges and specifications, not guilty. And then the trial would end. In the unfortunate event that you're found guilty of something, then the process known as sentencing happens. Usually there's a break. It's hard to move directly from a finding of guilt into a sentencing case. There needs to be some sort of break to decompress, to change gears, to get your mindset into not a not guilty mindset, but into a how do I minimize this particular case's negative impact. And so what happens then is the government is asked to present its case. The first thing they do is they read off the data from the charge sheet, and then they present any documentary evidence. Well, they generally present witnesses first, and then they present the documentary evidence. And with the witnesses, the same thing happens with respect to the cross-examination and cross-examination. Based on what the accused has elected, right, there's either going to be a panel who decides the case or the military judge alone, right? So we've made that tactical decision early on. So if there's a panel there, the panel could ask the questions. If there's not, the military judge could follow up with questions until the government says the government rests. And then the defense puts on its case in mitigation. And that's calling its character witnesses, its extenuation witnesses, and presenting any documentary evidence that we have for the judge or the members to decide. Again, the cross-examination, redirect examination process continues. When the case is done, what happens next is the military judge will then instruct the members, and then the government will argue for a sentence, and then the defense will argue. And in this case, the government doesn't get a second bite of the apple. It ends with the defense argument on sentencing. And then the members are excused if it's the members, or the judge goes back and deliberates. And however long that takes, it takes. And then the military judge comes back, the members come back, the same process repeats itself. Accused and counsel, please rise. And then you rise, and then that's when the judge announces the sentence. And that's basically it for what to expect in the court-martial process. After the process is over, after it's all said and done, whether or not you've been acquitted or you have to go to confinement, There are other issues that happen with respect to setting up an appeal, or I mean, if you're acquitted, you walk away and the game's over. You're done. Bye-bye. Hug your lawyer, go to the shop get something to drink, and hit your barracks room. If, on the other hand, you're going to the confinement, then there are some legal matters that need to be addressed before you head to the confinement facility. But that's what somebody can expect from a court-martial, from day one when that commander reads it to them to day 400 when you're acquitted or, unfortunately, sentenced to some type of punishment. We are the law office of William Helixon. We are your warrior advocates. You defend the nation, we defend you.